Comparing litigation versus arbitration. The default, if there is nothing in the contract, is that litigation will be the method of dispute resolution. So you can either have in your contract a submission to jurisdiction clause, whether exclusive or non-exclusive. If exclusive, the parties are agreeing which court will resolve the disputes. If non-exclusive, they're saying, at the very least, this court can hear the disputes, but other courts may also. Arbitration is a process by which the parties agree that the disputes will be removed from the courts and heard by an independent tribunal. So no court will have jurisdiction to determine the merits of any disputes that are within the clause if an arbitration clause exists. And why? We've gone through some of these reasons, but if you look at the bubbles on the right, you can see that the main reason for electing arbitration is ease of enforcement. So the ability to take an arbitral award anywhere in the world and enforce it against the counterparty, almost anywhere in the world. Additional advantages: neutrality and avoiding the local courts, as we've already mentioned. The choice of decision maker, because the parties have the ability to choose their arbitrators. If they have a single arbitrator, that will be selected usually by the institution or by the appointing authority, but they have some input into that selection. If there are 3 arbitrators, normally each party chooses, or each of the respective respondent and claimant groups chooses an arbitrator, and then those 2 arbitrators make the selection for the chair. As mentioned, confidentiality can be a driver. Additionally, flexible process. The arbitration is driven by the agreement of the parties and the rules under which the arbitration is placed. And the arbitrator or arbitrators have significant ability and power to adjust the procedural requirements to fit the needs of the parties. So rather than very constraining domestic court rules of evidence, for example, the parties in the tribunal can agree on the process for submission of evidence. And usually, rather than having strict rules of evidence, there will be weight and credibility issues given to evidence, but most evidence will be allowed in. There are disadvantages of arbitration, or things to think about more precisely as you're drafting an arbitration clause and selecting a seat. It's not always possible to get the same type of enforceable urgent injunctive relief in an arbitral process. So in some circumstances, you can go to the courts in aid of arbitration and get that relief. In other circumstances, that may be not possible or may be less enforceable against the counterparty, and that also the tribunal only has power over the parties before it, the parties that have agreed to the arbitration. It can't compel actions by third parties. Another area to take into consideration is that, as we mentioned before, in general, there is no right of appeal in an arbitration award. Some parties find this desirable because there's certainty in the finality of the award. Other parties find it concerning that they won't have an opportunity to challenge what they view to be an incorrect decision. There will always be a right to challenge on grounds set out in the New York Convention, which we'll come on to, but in general, those are for procedural violations, not errors of fact or law. Speed and costs. You will often hear parties who don't know much about arbitration saying, oh yeah, we'll use arbitration because it's faster and cheaper. In an international context with large transactions, that is not necessarily true, although there may be advantages to speed and cost by not having an extensive appeal process. But as a general rule, if you're talking about a large commercial arbitration, the parties are just as interested in a robust legal review of their dispute and a robust and reasoned decision determining their dispute in arbitration as they are in litigation. So although corporates may say that they want faster and cheaper proceedings, when they get into the proceedings themselves, what they really want is a legally robust process that is tailored to the circumstances and tailored to the size and complexity of the dispute. Because of the flexibility of the arbitral process and the power of the arbitrator to adjust proceedings accordingly, those efficiencies can be a real advantage of arbitration, but you have to choose an arbitrator or arbitrators that are willing to take those steps and implement those procedural flexibilities to benefit the parties. It can be more difficult in an arbitration to deal with multi-party and multi-contract disputes. Historically, the position was that because arbitration is consensual and because the consent is contained in an individual contract, the arbitration had to be under that contract between the two parties or multiple parties that signed that contract. Increasingly, arbitral institutions are amending their rules to make it easier and more flexible to allow the consolidation and joinder to bring in multiple parties or multiple contracts that are in a single related transaction. Therefore, it just requires selecting, if you know that you have a multi-party, multi-contract situation, particularly in large construction disputes, you want to make sure that you're structuring your arbitral agreement or arbitration agreements sufficiently to capture the ability to bring together any disputes that you want to be heard together. There's also an issue of relative bargaining position. So if you have, in most international commercial arbitrations, you have large corporates that are in relatively equal bargaining position, but in some types of situations, you may have significant imbalance between the parties, and that's just another thing to take into consideration.